Welcome to our latest HR update, and as has become customary, it's available in this video form and also in written form on the JCHR website. April is the month most statutory updates of employment law are brought into effect, and in this update I'm going to look at the various employment law changes arriving this month. Before looking at the more immediate changes, let's remember that it's election year and virtually everybody is predicting a change of government. So what will a Labour government mean for employers and employment law? Angela Rayner published a green paper outlining Labour's intentions in precisely this area, and these include the ability for employees to bring an unfair dismissal claim from day one of employment. The law currently requires 2 years service for that. They'll also harmonise worker and employee status, ban 0 hours agreements, and create sector-by-sector fair pay agreements. These are European-style agreements that will set minimum terms and conditions and dismissal compensation arrangements on a sector-by-sector basis, and those fair pay agreements will also involve and promote the influence of trade unions, particularly in sectors where they've had limited success previously. I can't overstate the significance of some of these policies. If they're implemented, they will have a huge impact on employers, and these are just a few of the changes proposed. If you want to read more about Labour's plans for employment law, just follow the link that's on screen. That will take you to our HR team at my HR department's news pages. Before looking forwards, let's take a little look back, because January saw the new Preventing Illegal Working Code of Practice, which comes with increased fines, £45,000 for a first offence of employing an illegal worker, and up to £60,000 for repeat offenders, and that's for each illegal worker that's employed. So employers should definitely review their policies and procedures, particularly around recruitment and checking of eligibility to work, and make sure that they comply with these new changes. If you want to read the code, the link again is on screen. That will take you to the government website, which goes through the requirements. Okay, let's get back to April and this month's changes then. So from this month, we'll see changes to how holiday pay should be calculated. And we'll also see the legalisation of rolled up holiday pay for workers with irregular hours or who work for just part of the year. So from the new pay year, starting on the 6th of April, employers will be permitted to roll up holiday pay into wages, basically paying a supplement to reflect the accrued holiday. And those employers who only provide the minimum holiday entitlement, equivalent to 5.6 weeks per year, can calculate holiday pay for those workers at 12.07% of earnings. These changes stem largely from a case law decision that previously resulted peculiarly in some part-year workers receiving proportionately more holiday pay than their full-time counterparts. While many employment and HR advisors encourage their clients to adopt convoluted formula to accommodate the impact of that case, our HR team at my HR department took a more pragmatic view and took a policy decision to recommend clients continue to use 12.07% as the calculator. We predicted, correctly as it happened, that the legislators would fix the problem. Rolled up holiday pay has been unlawfully used by many employers for years anyway, and so this is a case of the law catching up with practice. But do bear in mind that one of the Labour Party's stated employment policies is to ban 0 hours contracts, and if they can actually implement that, and at JCHR I have to say we're not sure whether they can in practice, but if they can, then these changes will become largely obsolete. Okay, the national living wage and the national minimum wages from 1st of April will increase significantly. For the first time, the top rate, the national living wage rate, will apply to workers aged 21 and over. Now, the last holiday year, it was 23 and over, and not so long back, it was 25 and over. Aside from the drop in eligibility for the top rate, a drop in age eligibility for the top rate, I should say, it's increased by 9.8% to £11.44 an hour. It's worth noting that the Low Pay Commission, which is the body that recommends national living wage increases each year to government, has already suggested that the top living wage rate should apply to 18-year-olds and above. And so I think we can expect to see the age eligibility for the top rate reducing further in years to come. Other rates increased this year, though, by 21.2%. So for employers who pay the minimum wage for, in particular, a young workforce, this is going to be a very expensive year. To see all the new rates, please see our earlier article or watch the video by following the link which is there on screen. And again, that will take you to our HR team's website, My HR Department. Other statutory rates are increasing in April too. Guarantee pay, which is the statutory payment employers have to make for workless periods, well, that increases by £3 a day to a whopping £38. And statutory sick pay is increasing to £116.75 a week, and all of the various forms of statutory paid family leave increase to a maximum of £184.03. April sees the arrival of a new employment right too, and this one is for employees with dependent care responsibility. The right bestows an entitlement to 1 week's unpaid leave each year to provide or to arrange for the provision of care for a dependent. The leave is unpaid and it can be postponed by employers if the timing of the requested dates would cause operational difficulty. Now, some employers might choose to enhance this right, perhaps by providing pay for some or all of the week, or by choosing to extend the period beyond the statutory minimum of a week. Refusing an eligible employee permission to take their entitlement to carers leave would amount to a breach of contract and could attract financial penalties, including for unfair dismissal in certain circumstances. Women on maternity leave are given special protection from being made redundant if a redundancy comes about while they're on maternity leave. But from this month, that special protection is extended. It now includes the whole of the period of pregnancy and also the 6 months after the employee returns to work after maternity leave, with similar rights extending to adoptive parents and to those taking 6 or more consecutive weeks of shared parental leave. There is a new day one right to request flexible working as well. And employees now are able to make 2 requests in each 12-month period. So flexible working requests can be made from day one of employment, and whereas the old regs allowed 1 application per year, it's now increased to 2. There's also a requirement within those regulations for employers to consult with employees if they're thinking of rejecting the request. And there's a reduction in the period required for the employer to respond to the request. That reduces from 3 months to 2 months, and that includes the appeal stage of that process. And lastly, on flexible working requests, whereas in times gone by employees had to set these out quite formally, that requirement of formality has now been removed, and requests can be made in a variety of ways. In July, we're expecting to see amendments to TUPE, and TUPE will be amended to allow for employers who have less than 50 staff or employers of any size who are proposing the transfer of less than 10 staff to consult with employees directly. Under existing regulations, employers often have to elect representatives for this purpose, although again our HR team at JCHR have always taken a more pragmatic approach when advising clients, particularly on small scale or low impact transfers. The Employment Allocation of Tips Act is coming into place in July as well, and this will be of interest to our licensed resale clients. That Act aims to ensure that 100% of tips are distributed fairly and transparently among workers, and the draft code of practice for that is already in place, and the link is on screen there. Around September, we're also expecting a new right for employees with unpredictable terms and conditions, and 0 hours employees will often be included there. A new right for them to be able to apply for greater predictability of, in particular, their working hours. And lastly on this slide, in October there will be a new duty on employers to prevent sexual harassment. The national press and our HR teams here at JCHR and My HR Department have featured numerous articles concerning sexual harassment.
This new duty will require employers to take reasonable steps to prevent sexual harassment in the workplace, and should they fail to do so, any resultant tribunal award may be uplifted by 25%. Last year, we released training and communication materials to enable JCHR clients to quickly and easily help raise awareness of sexual harassment. And our videos and resources have been accessed thousands of times, and they will remain free for our clients to use, and we'll be issuing refreshed versions throughout this year. We're also expecting at some point, there's no firm date for it yet, but we're expecting a 3-month statutory cap on non-compete clauses. These clauses often feature in restrictive covenants contained in employment contracts, and in recent times we have been advising clients to try to restrict restrictive covenants to shorter periods, which are more likely to be enforceable anyway. Returning to the April changes, the annual increase in compensation limits in employment tribunals comes into play, and this year's numbers are a little bit more memorable. So a cap on a week's pay for the purposes of calculating redundancy pay increases to a nice round number, £700 a week. The maximum unfair dismissal award increases to £115,115, which is quite easy to remember. And our good friend and barrister Daniel Barnett pointed out that that looks very much like a telephone number for directory inquiries, and it does, doesn't it? The new weekly cap on a week's pay of £700 means that the maximum statutory redundancy payment, which is capped at 20 years service, is raised to £21,000. And that would be for someone who had worked for 20 years, all beyond the age of 41, when statutory redundancy payment compensation increases to 1.5 weeks per year of service. So 1.5 weeks at 20 years is 30 weeks. Times that by 700, 21,000, that's the maximum. Earlier in this article, we covered the minimum wage and living wage increases from April. To date, HMRC have unearthed 524 employers who failed to pay that, and the most common reason for that was salary sacrifice schemes, or rather the effect of them, where employees sacrifice some of their gross pay in exchange for a benefit, like an electric car perhaps. Many employers have fallen into the trap of allowing employees to sacrifice too much pay, resulting in their gross pay falling below the national minimums. If you offer salary sacrifice schemes, or you're planning to, then this is a point worth considering. The link on the slide here will take you to our HR team's article, which looks at this and the other reasons why employers have missed their minimum wage obligations. Finally, the GMB union, a union often responsible for coordinating strikes, are suffering a dose of their own medicine. Their own staff are going on strike. GMB's staff are striking over an alleged toxic, misogynistic culture within the GMB. That was unearthed a few years ago by an independent inquiry, but, say the GMB staff, this has never effectively been dealt with. If you want to read more about that particular case, then the link is on screen for you there. I hope that update was useful. My HR department is an independent, family-run business. We are the HR team supplying HR services to the clients of JCHR. We're not a franchise. We provide HR, we provide payroll, employment law, health and safety services. We also recruit for HR and other vacancies. While we're a prominent provider of outsourced HR and payroll, we also support in-house HR teams, most usually by helping with their employee relations cases and with their employment law needs. For a no-obligation assessment of how partial or full outsourcing could help your organisation, or indeed to discuss any of our other services, please contact us and we'll be happy to arrange a Teams meeting or attend in person if you prefer. Thank you for taking the time to watch this video, and I look forward to seeing you again very soon.